this?
This was massive. The sheriff says the drug trafficking organization had been doing this for about 6 years here in Central Florida, and today was the culmination of law enforcement's 2-year investigation.
And investigators say the group did more than just deal drugs. They've tied the suspects to everything from money laundering to murder.
5:17 a.m., Coral Gables, Florida, the 18th of April, 2026. More than 380 criminal cases flagged for review. $42 million in assets seized. A $2 billion judicial case fixing network tied to criminal activity just exposed. A county sheriff has been arrested. 29 licensed attorneys taken into custody. At least 63 additional individuals are now under federal investigation, including court personnel and active duty law enforcement officers. Not criminals hiding in the shadows, but state licensed professionals, officers sworn to enforce the law. Attorneys trusted to defend it, now accused of turning the justice system into a corrupt network that betrayed public trust. In just 70 seconds, FBI and ICE tactical units breached a $15.6 million private waterfront estate. Every entrance was sealed. Internal networks isolated, all communications cut before a single file could be deleted. This was not a drug raid. This was a system collapse. Inside the mansion, agents recovered 3 encrypted accounting ledgers, documenting payments over more than 4 years, each tied to specific cases, defense attorneys, and judicial reference codes. One ledger alone recorded over $8.7 million in processed transactions. But the numbers were only part of the story. In the main office, agents began cataloging the first pieces of evidence. Inside a reinforced safe, they discovered $1.7 million in cash, vacuum-sealed and stacked in identical bundles, each worth $50,000. The arrangement was precise, repetitive, methodical, hidden behind a false bookshelf in the sheriff's private office. Agents uncovered a secured room. Inside, multiple computers, an active case monitoring system, and a large board tracking ongoing criminal cases across 3 Florida counties. Each case marked with handwritten notes reduced, dismissed, delayed, alongside figures ranging from $2,500 to over $25,000 per case. Internal communications referenced postponed hearings, missing evidence, and judge reassignments. Then, a shocking discovery. Narcotics present on site. 20 kilos of fentanyl hidden in a cabinet. 25 kilos of cocaine found in the kitchen. Within the first review alone, investigators identified over 140 manipulated cases with estimated illegal payments exceeding $18 million, and that represented only a fraction of the data inside the room. The network also showed direct links to drug trafficking, tied to a high-ranking law enforcement official. What they entered that morning was not a home. It was a command center, a place where outcomes were negotiated, where evidence could disappear, where justice had a price clearly listed, carefully tracked, and quietly enforced. By 6:02 a.m., federal supervisors made the call. This was no longer a corruption case. This marked the beginning of a full-scale federal investigation into what officials would later describe as a billion-dollar case fixing network operating from within the very system designed to protect the public. If justice can be priced, how many verdicts out there are truly real? Comment truth if you believe this is only the tip of the iceberg, and share this video because what we are about to reveal next is far bigger than anyone expected. Federal. Officers at the press conference today say the people work for an operation that moved cocaine and fentanyl across the state for over 5 years. His members engaged in acts of violence and murder. They possessed and used firearms, and they laundered drug proceeds and engaged in fraud. By 6:20 a.m., the atmosphere inside the estate had changed. What began as a high-level anti-corruption raid was now being handled as something far more calculated. Agents moved carefully through the hidden room, documenting every file, every screen, every handwritten note. What they were examining was not random evidence. It was a system. Within the first 2 hours of analysis, federal agents identified more than 230 individual transactions spanning nearly 3 years. The total amount recorded in those ledgers exceeded $27.4 million. The transactions appeared routine legal fees, consulting notes, court references. But when analysts began cross-checking these entries with public court records, a pattern emerged that could not be ignored. Every payment corresponded to an outcome. Cases marked dismissed had matching deposits. Cases labeled reduced were linked to specific attorneys. Delays, postponed hearings, missing witnesses, all aligned with the recorded financial activity. The structure was precise and consistent. Defendants did not approach judges directly. Instead, they were directed to a network of defense attorneys, trusted intermediaries who understood exactly how the system worked. These attorneys acted as negotiators, setting prices based on the severity of the charges. Minor violations, traffic offenses, probation violations ranged from $300 to $800. Low-level criminal charges, possession, nonviolent offenses, ranged from $1,000 to $5,000. Serious felony cases, including drug trafficking, assault, and repeat offenses, ranged from $10,000 to over $50,000 per case. Every outcome had a price, and every price had its own pathway. Initial findings suggested that more than $2 billion had been influenced by manipulated case outcomes spanning multiple counties and jurisdictions. Over 300 active and closed cases were flagged for irregular patterns, dismissals without justification, charge reductions without supporting evidence, and repeated appearances of the same attorneys linked to unusually favorable rulings. But what made this operation truly dangerous was how it functioned. They did not break into homes. They did not rob banks. They did not smuggle drugs across borders. They used courtrooms, legal records, federal case numbers, and procedural codes. And above all, they relied on trust across Miami-Dade, Orlando, and extending into parts of Georgia and South Carolina. Federal teams operated in complete silence to secure something more valuable than anything else: data. Because once the system realized it had been compromised, everything could disappear in seconds. Inside a private law office in downtown Miami, investigators uncovered what they described as a case coordination hub, a command center disguised as a law firm. Multiple terminals were actively tracking court schedules, judge assignments, and defendant records in real time. This was not legal defense. This was case management on an industrial scale. Evidence collected at the scene showed the network was influencing the outcomes of more than 20 cases per week, generating illegal payments that during certain periods exceeded $5 million per month. To the public, everything appeared normal. Court hearings continued. Judges issued rulings. Attorneys argued cases. But beneath the surface, outcomes had already been decided long before anyone entered the courtroom. And, for those trapped inside that system, there was no way to distinguish what was real and what was not, because on paper everything appeared legitimate. And that was the most dangerous part. If you think this is just another corruption case, you are mistaken. Stay with us, because what federal agents uncovered next will expose something far bigger than bribery. It will expose a system where justice itself has been turned into a transaction. Up to that point, the evidence pointed to a highly organized, structured, and profitable case-fixing operation deeply embedded within the system. But when federal analysts cross-referenced the accounting ledgers with actual case records, a darker picture emerged. This was not just about manipulating outcomes. The objective was to control the entire process from the very beginning. Inside a separate storage cabinet, agents recovered internal police reports tied to dozens of case numbers matching those in the ledgers. At first glance, the reports appeared normal, standard formatting, official signatures, complete documentation. But when compared with court records, the inconsistencies became impossible to ignore. Evidence files were incomplete. Key witness statements were missing. Chain of custody forms contained unexplained gaps. In more than 72% of over 260 reviewed cases, critical elements had been weakened before reaching the courtroom. This was not coincidence. It was design. Investigators realized the process did not begin with judges or attorneys, but at the first point of contact, the police report. Officers involved in initial arrests had quietly altered records. In some cases, they failed to document key evidence. In others, they misfiled documents, making them legally unusable. Some reports used vague descriptions instead of detailed observations, creating enough doubt to challenge entire cases. In at least 38 confirmed cases involving more than 1.2 tons of controlled substances, officers failed to appear in court, leading to dismissals due to lack of testimony. But the manipulation did not stop there. Payments were recorded in return, ranging from $2,000 to $15,000 per transaction, carefully documented in the same ledgers recovered from the hidden room. Then came the most controlled layer, court administration. From there, funds were routed into international accounts across the Caribbean and Southeast Asia. Data from seized computers revealed patterns in court scheduling that could not be explained by chance. Cases marked in the ledgers were consistently assigned to the same judges. Hearing dates were adjusted, sometimes repeatedly, aligning precisely with payment timelines. Investigators identified more than 190 instances where judicial assignments appeared influenced. Clerks, administrators, and scheduling coordinators had quietly become part of the system. By early afternoon, the structure became clear. Police weakened cases, attorneys negotiated prices, court staff arranged conditions, and judges delivered final rulings. Every step was connected. Every role was compensated. Every outcome was predictable. What made it effective was not just secrecy, but coordination. Money moved carefully, often in cash, through envelopes, private meetings, or coded references in legal documents. No direct transfers, no clear financial trail, no easily traceable digital footprint. And yet the ledgers told the whole story. Over 3 years, investigators estimate more than $42 million was distributed within the network, influencing over $480 legal outcomes while remaining hidden in plain sight. Then came the most alarming discovery. Recovered documents referenced sensitive cases flagged for priority handling. In several instances, defendants facing serious charges, including violent crimes, had their cases reduced or dismissed under unusual circumstances. In at least 12 cases, individuals who should have faced long-term prison sentences were released within months, not due to lack of evidence, but because the evidence had been engineered to fail. Investigators now believe this network not only controlled legal outcomes, but also shielded other operations, creating protected corridors where certain individuals operated beyond oversight. A dual system. On one side, it extracted millions and corrupted the courts. On the other, it created a controlled environment where risk was managed and exposure minimized, carefully disguised, perfectly coordinated. By early afternoon, the conclusion had become unavoidable. This system could not be dismantled from the outside. It had to be entered from within. At 1:40 p.m., Federal Command authorized a covert expansion of the investigation. The operation would no longer focus solely on gathering evidence. It would move into active infiltration. What followed was a strategy rarely deployed at this scale, a controlled penetration of the very network under investigation. Within weeks, undercover operatives were embedded inside the system. One posed as a defense attorney representing high-risk clients. Another operated as an intermediary, a broker tasked with facilitating outcomes. Others were placed in positions where they could observe internal court procedures without raising suspicion. Their objective was simple: track the money, document the process, prove the coordination. Over the next 9 months, the operation expanded across 3 counties. Every meeting, every exchange, every conversation was recorded under federal authorization, hidden microphones, encrypted surveillance devices, pre-marked currency. What they uncovered confirmed everything and went even further. In more than 210 recorded interactions, undercover agents documented direct negotiations between attorneys and individuals connected to the court system. Payments were openly discussed. Outcomes were implied before hearings even took place. In one case, an undercover operative offered $12,000 to resolve a felony charge. Within 48 hours, the case was reassigned. Key evidence was declared procedurally invalid, and the charge was reduced to a nonviolent misdemeanor. In another case, a payment of $7,500 resulted in a complete dismissal. The arresting officer failed to appear, and the case was closed in less than 3 minutes. But the most critical breakthrough came when agents tracked the movement of marked funds from the defendant to the attorney to a secondary contact and ultimately into accounts, or assets linked to officials within the system. Throughout the operation, federal investigators traced more than $6.8 million in controlled transactions, each one mapped, recorded, and verified. This network was not improvising. It was operating with precision. By the 6th month, its scale had become undeniable. 29 defense attorneys actively involved, 14 court personnel identified in administrative manipulation, multiple law enforcement contacts linked through communication logs, and several judicial figures, named for repeated interference in high-value cases. More than 520 cases are now under review, and in at least 310 of them, evidence shows coordinated interference. At 4:55 a.m., nearly 1 year after the initial raid, the final phase began. Federal task forces were deployed simultaneously across 21 locations. No prior notice, no local coordination. Every unit operated under strict federal control to prevent internal leaks. Doors were breached, offices secured, equipment seized. Within 1 hour, more than 60 individuals were taken into custody for questioning. Among them were attorneys, administrative staff, and individuals directly tied to court operations. Primary targets, including key coordinators within the network, were arrested under sealed federal warrants. By 7:10 a.m., the operation was complete. All evidence, thousands of hours of recordings, financial records, and internal communications was now in federal custody. For the first time, the entire structure had been exposed not through theory but through direct participation. As one senior investigator stated, "We didn't just observe the system. We became part of it long enough to prove how it works." But even as arrests unfolded, one reality remained. This network had operated undetected for years. It had influenced hundreds of outcomes. It had rewritten the meaning of justice, one case, one payment at a time. And now, as it is finally exposed, the question is no longer how it worked. The question is how much damage has already been done and whether any of it can truly be repaired. By 8:30 a.m., the arrests were only the beginning. What followed caused even greater disruption, not just for individuals, but for the entire structure of the justice system in that region of Florida. Within hours, federal prosecutors filed formal charges and the case expanded rapidly into one of the largest judicial corruption prosecutions in recent U.S. history. At least 92 individuals were charged, including 29 defense attorneys, 17 judges and judicial figures, and more than 30 police officers and court staff linked to falsified evidence and procedural interference. The charges were severe racketeering, bribery, obstruction of justice, witness tampering, and conspiracy to manipulate criminal outcomes for financial gain.